Good evening, folks. Welcome Wednesday night. Welcome to our finale. This is our new night court show finale. We've viewed, or aired, rather, I should say. We've aired 4 episodes of a single court case. This is a court case out of Texas, where a gentleman is being charged with possession of a short-barreled firearm or short-barreled shotgun, which is a prohibited weapon in the state of Texas and on the federal level as well. But these are state charges we've watched. We've heard the indictment. We listened to the testimony from both sides, the state's case, the defense's case. We listened to the closing arguments, and we finished up with that. Tonight, you guys are the jury. Tonight, you guys are going to deliberate. You're going to make your decisions. It has to be a unanimous decision. And we're going to ask you to follow the judge's instructions. I'm literally going to play the judge's instructions to the jury for you, so that you can make your decision in the same way that the real jury was asked to make their decision. Once you guys have deliberated, we're going to play the real verdict and see what happens and see what the real jury came up with, to see if our view matches their view. Tonight we've got Hawk from X. Hawk, introduce yourself. I'm going to ask each one of you juror members to introduce yourself before we get started. But Hawk, you start the game off there. Tell folks about yourself.
Hey, everybody. I'm on X for, political commentary, that sort of thing. Pretty much it's a social media, so I go on for social. But I have a focus that I'm actually pushing, and that is veterans issues, helping veterans with VA, working through the VA system, working on their VA disability, that sort of thing. And that's really a passion and a focus that I have on X, and it's one of the things that I actually have a community for that. But that's what I do on X, other than have conversations.
Thanks, Hawk. Just me. Tell folks about yourself.
Hey guys, I live in Florida. I'm a researcher, helping out Joe tonight, and I'm just here for this show. So,
well, I'm glad you're here for the show. That's what we're all here for, to make that happen. We've got Tyler J. Beasley. You guys may recognize him. He's been on the grand jury a couple of times. He's going to be a juror for us again tonight. Tyler, tell folks about yourself. You're muted, my friend.
Oh my, I'm so sorry. I didn't realize I was muted. So yeah, as many of you know, I am Tyler. I've been on the show 2 times now. Absolutely love being here. I'm going to keep coming back. I will be in the next series again after tonight. So you guys get to see my beautiful face for the next 5 weeks. I'm a guy that likes to get up off your ass and kind of do shit, as Joe has mentioned. So yeah, just here to help my buddy Joe out, and see justice through, and because I love doing stuff like this.
We appreciate you, Tyler. Moon Goddess, tell the world about Moon Goddess.
Oh goodness, there's not much to tell. I am a mom. I'm old, and I love the show. I love what you do, Joe. I think it's awesome. Very entertaining. Plus, it's very educational and learning about how our judicial system works, the ins and outs. And I'm just happy to be here.
We appreciate you, Moon Goddess. Now, we have 2 of our night crew folks that are sitting on the jury tonight. One you may know, but you might not. You haven't seen him in a while. And that's Vet LT3. Vet LT3, introduce yourself, please.
Hello, Joe. Hello, everybody. Yep. Vet LT3, as the name says, I am a veteran, Army, 8 years, business owner, and also, I guess you want to call it prepper, and have my own little tribe that I'm a part of here in Kentucky. And yeah, I was part of the night crew for a long time, and I still am, and just been very busy doing my day-to-day life. And it's always a pleasure to jump in and hang out with Joe and the crew. And Joe's a good friend, and I'm always here for Joe, and he knows that.
Vet is a good guy. That's a busy man in Kentucky, folks. Vet LT3 is. And we've got B. Wayne. You guys probably have seen B. Wayne. He's been in some of the weekly shows on this episode. B. Wayne, what do people need to know about you?
How's it going, guys? Thinker, drinker, constitutionalist, co-host of the Night Court with Joel and New. Excited to see what we're doing here tonight, and thank you all for joining. It's going to be great.
All right, folks. Tonight you are the mock jury. You're going to be asked to decide using the jury instructions that the judge is going to give you to make a decision on this case from the facts that you've heard over the last 4 weeks. You can ask questions, but only ask questions once we begin the deliberations. That's the way it works with a criminal jury. Once we release you for deliberations, you're going to speak amongst yourself. Tonight, just me has been elected the jury foreman. She'll lead the deliberations in accordance with the jury instructions. And we're going to give you probably about half an hour, a little longer than we normally do on a regular case, because there's a lot more information in this than a grand jury case. And we're asking you to be convinced beyond a reasonable doubt. That is one of the instructions that you're going to receive. So we'll let you deliberate probably about 30 minutes, maybe a little longer if we're stuck. Once you guys deliver a decision, we're going to unveil the real decision that the real jury came up with in this case, hearing the same evidence that you guys heard. That's the way this was cut. You heard everything that the jury heard, not one word that they didn't, and nothing was excluded from you, just as the real jury would have heard. So any questions before we go to the jury instructions?
No, sir.
Okay, let's get to the judge's jury instructions. Now, this is going to go on for a bit. I'm going to let it go. Some of it's dry, but listen very closely. The judge is going to instruct you on how you are to deliberate this case. And he'll tell you, if you come up with this set of facts, then you must your verdict must be this. If it's another set of facts, then your verdict must be that. The jury instructions are very clear to the jury, and they're very detailed. So let's listen to them.
All right, let the record reflect that the jury is now present and seated in the courtroom. All right, ladies and gentlemen, at this time, I'm going to read the charge of the court containing the law applicable to this case and continuing to discharge your responsibility as jurors. You will continue to observe all the instructions that have previously been given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, the parties, the attorneys, and myself. If it should be found that you have disregarded any of these instructions, it will be jury misconduct, and it may require another trial by another jury. If any of you observe one or more of your number violating any of these instructions, you shall immediately warn the violator and caution him or her not to do so again. Please listen carefully as I read the charge to you. And a copy has been provided to you for your reference. Jury instructions. Members of the jury. The defendant, Reginald Hoyt Young II, is accused of the offense of possessing a prohibited weapon. You have received all the evidence and must now decide whether the defendant has been proved guilty of an offense. Both sides will soon present final arguments. Before they do, I must now give you the instructions that you have to follow in deciding whether the defendant has been proved guilty of an offense or not. You will have a written copy of these instructions to take with you and use during your deliberations. First, I will tell you about some general principles of law that must govern your decision of the case. Then I will tell you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles. Indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. Unless all jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. Jury as fact finder. As the jurors, you review the evidence and determine the facts and what they prove. You judge the credibility of the witnesses and what weight to give their testimony. In judging the facts and the credibility of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by attorneys during the trial are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of the testimony of the witnesses and materials admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may examine exhibits if you wish. Only exhibits that were admitted into evidence may be given to you for examination. In order to inspect the weapons admitted into evidence, you must submit a request in writing to the court. Testimony. Certain testimony will be read back to you by the court reporter if you request. A request must follow these rules. The court will allow testimony to be read back to the jury only if the jury, in writing, signed by the foreperson, states that it is requesting that testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The verdict. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty means that the state's evidence does not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. Defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Specific law applicable to this case. Accusation. The state accuses the defendant of having committed the offense of possessing a prohibited weapon. Specifically, the accusation is that the defendant did intentionally or knowingly possess a short barrel firearm and Eastern Arms 16-gauge shotgun. Applicable law. A person commits an offense if the person intentionally or knowingly possesses a short barrel firearm. To prove that the defendant is guilty of possessing a short barrel firearm, the state must prove beyond a reasonable doubt 2 elements. The elements are that 1, the defendant possessed a short barrel firearm, and 2, the defendant did this intentionally or knowingly. The state must prove beyond a reasonable doubt the accusation of possessing a prohibited weapon. Definitions: possession. Possession means actual care, custody, control, or management. Intentionally. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. Knowingly. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Firearm. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by this chapter, and that is an antique or curio firearm manufactured before 1899, or B, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition.
Okay, I want to pause there for a second. He's given some very specifics. Everyone understands his meaning of possess. Any issues, any questions there with anyone on the meaning of the word? Because that's an element of the offense the state has to prove, that he was in possession, care, custody, and control of this short-barreled shotgun. The other is the definition of a firearm. Very specific there on what we're talking about. If it was a muzzle loader that had what they call an antique ignition system, like a flintlock, something like that, or you had to put blasting caps on a nipple to shoot it. These older weapons beyond 1899, then that's not considered a firearm under the statute. Any questions so far with the jury instructions?
I have one.
Go ahead.
He said that readily available, that could be readily available to be fired. That includes a firing pin, correct?
Well, you're the fact finder. He also said that you're the fact finder in this, and that is what the state is proposing. That the fact that the shotgun did not have a firing pin did not make it not a firearm, because putting a firing pin in is a minor task to perform.
But okay, all right.
It sounds like you're deliberating. If you got a question about that,
Yeah, I know. I'm sorry.
Okay, let's finish up with the jury instructions.
Short barrel firearm. Short barrel firearm means a rifle with a barrel length of less than 16 inches or a shotgun with a barrel length of less than 18 inches, or any weapon made from a shotgun or rifle if, as altered, it has an overall length of less than 26 inches. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt 2 elements. The elements are that 1, the defendant in Van Zandt County, Texas, on or about November 25th, 2020, possessed a short barrel firearm, and 2, the defendant did this intentionally or knowingly. You must all agree on elements 1 and 2 listed above. If you all agree the state has proved beyond a reasonable doubt each of the 2 elements listed above, you must find the defendant guilty of possessing a prohibited weapon as charged in the indictment. If you all agree the state has failed to prove beyond a reasonable doubt elements 1 or 2 listed above, you must find the defendant not guilty of possessing a prohibited weapon as charged in the indictment. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the...
Yeah, we don't, he's going to give some utility instructions there. So let's go ahead and pull that down. That's your jury instructions. Now, folks, they talked about two elements that the state had to prove. One was that the defendant was intentionally or knowingly in possession. So possession is the first element. Second element is of a firearm that was in a shotgun that was less than 18 inches in barrel length and overall length of less than 26 inches. So those are the two elements. If you find yes in both of those, the state's asking you to come back with not guilty. If you think that the state did not prove one of those two elements, then the state is asking you to render a verdict of not guilty. That's quite simply what the instructions are. Does anybody have any questions about the instructions? If not, I'm going to give a little bit of a closing argument for you. We're not going to go back and listen to the attorneys because there were three iterations of that. You had the prosecution twice and the defense once. The prosecution's case is just this, that while doing an investigation into a burglary, deputies from the Smith County Sheriff's Office went to an address in Van Zant County, located a suspect in this burglary, which was not the defendant in this case. It was another person. The state says that while conducting this investigation, they obtained a search warrant out of courtesy. They let the Van Zant County Sheriff's Office know, and they responded in kind because there's a agency in their jurisdiction serving a search warrant, and they're there to assist. It's very common. Van Zant County comes, and during the subsequent search of this residence, they do find items from the burglary, but that's not important in this case. But what they do find in a freezer outside, this freezer sitting outside on the ground, inside the freezer is a short-barreled 16-gauge shotgun, just as the judge described. This shotgun did not have a firing pin. While they're on scene, they interrogate or question all persons on scene, including the defendant in this case. The property they were at belonged to the defendant's mother. She was out of town in an extended trip to Phoenix, Arizona. The son is there. He claims checking on the property. The state maintains that he was living there. He says that I was not living there. The state maintains that he was absolutely living there and therefore fully in possession and control of all contents on that property. Through an interrogation on site and an interview on site, recorded interview on site, he's asked by a DEA agent about this shotgun. He says that, well, it's my mother's, a friend of my mother's, and she brought it here. He kind of presses a little bit. Well, it's a federal charge. I mean, if we're talking about your mother being in possession of a short-barreled shotgun, that's a federal charge. He subsequently doesn't change his story, but he relents the fact that, well, yes, I knew it was there. It's not mine. I've never shot it, but I knew it was there. He goes from that point to acknowledging that he moved it from his car to this freezer. The state says that's how they prove possession. On the witness stand, we saw investigators from Van Zant County pull out a tape measure and gave you the length. 11 inches and a quarter, I believe, is what the barrel is when it was required to be 18 inches. And an overall length of 24 inches, I believe. So the length both ways makes this a prohibited weapon. This is what the state says they proved both their elements. He was there. He was in care, custody, or control of the property. Made statements of acknowledging and knowing that the short-barreled shotgun was there, and that after further examination, this short-barreled shotgun was in fact short-barreled and short overall length. Both of them are felony offenses in the state of Texas. The defense maintains, you heard the defendant's mother get on the witness stand and say that, no, that shotgun come from another friend of theirs with a few other items. He was going to jail. He asked that somebody retrieve these from his home and keep them and keep them for him for when he gets out, that she did do that. She's unaware of what's going on the property, hadn't been on the property in some time. She's unaware of what's going on with the property. The defense is saying that just because the firearm was there, that he may be there even in a caretaker's role, but he did not knowingly or intentionally possess that. For the fact that it was in a freezer, they didn't catch it in his hands. They can't put it in his hands outside of his own statement. So that's what the defense says. The state didn't meet its burden of proof on this. Now, there is the aspect that Moon brought up. The fact that this shotgun did not have a firing pin. I will say the defense didn't lay in heavy on this as far as that makes it a non-functional firearm. You can't shoot without a firing pin. But I will tell you the state, through a state and sheriff's office investigator and the DEA agent, made it very clear that the firing pins are readily available. They're easy to find. And I believe the term was any idiot can put it in, was one phrase. And the other phrase was it's just as simple as putting a round peg into a round hole. The state maintains that for the fact that it's such a minor alteration or a minor task to put a firing pin into that is a readily convertible weapon. And you heard that in the jury instructions, that it's readily convertible. That makes it a firearm. So with that, do we have any questions before we turn this over to deliberations?
Yes. Joe, can you just repeat what you said about the gentleman saying that did he say he retrieved it from his car and put it there?
He did say that. Initially, he said that this is my mother's house. The contents belong to my mother. I don't know about the shotgun. Then
Okay,
there was
so
some
he
talk about it
changed.
being a federal charge, and they pressed him a bit more. And this was the DEA. I mean, the ATF. If I said DEA, I apologize. It was an ATF, alcohol, tobacco, and firearms federal agent that testified and was on scene that day. He says that through my training and experience, I could tell that he was being evasive, so I pressed him on this issue. And he pressed him by saying, this is a federal offense, and that's your mother. Is that what you're saying? Is that what you're telling me? And he's kind of waffles back and forth. Well, no, I mean, I might have got it out. I got it out of the car. I put it there, but I didn't have anything to do with it. It's not mine, is what the defendant maintained.
Wonderful. Thank you.
All right, just me. You've got two elements that the state must prove. One is was he in possession, the legal definition of possession, and was the 16 gauge shotgun short in length? Those are the two things that the state's asking you to decide. So with that, I'm going to turn it over to the foreman, just me. You guys talk it out. I'm going to put you on the clock. 30 minutes. Go ahead.
Okay, guys, so you hear that we have to deliberate on these two elements. Let's see. I can't really see who everybody is on the thing, but I know, Moon, you're in here. What did you see? What
Yep,
are you
I'm here.
thinking? What are your thoughts on it?
Right now, should we take like a vote and see where everybody stands?
So I don't know. Deliberate a little bit first so we can talk about it. Do you think that
Okay.
the state proved these two elements without a shadow of a doubt?
I believe they proved that it was a prohibited weapon, although I do have questions about the chain of custody being broken. I have a hard time with that because they didn't follow protocol, obviously. And as far as the intentionally knowing, he didn't change his story until after the ATF threatened his mom. And so I'm on the fence, but leaning more towards not guilty per se, that I don't think that they proved beyond a reasonable doubt.
Okay. The part the judge wanted to make sure to make very clear is that we're not taking any of those outside elements in. Honestly, he can fight that chain of custody in an appeals court. But either way, the judge wanted us to stick to just if the state proved their case on these two facts. So you
Right.
say yes on one, but you're waffling on the other.
Right, yeah. There's all the things taken into consideration, all the testimony that was given with the contradictions in the testimony between the officers. It's really hard to
What contradictions?
really know what happened that day.
What can you name a contradiction that stuck out to you?
Well, the detective, the arresting officer, whatever, oh God, what was his name? Not the first detective, but the second one from
The Van Zant
Van
County,
Zandt.
the sheriff's investigator was the arresting officer. You're correct.
Okay. All right. He said that without the firing pin or that it wasn't operational, so therefore it wasn't prohibited, where then the ATF agent says, yes, it is a prohibited one. And so that
let me help you with that. Neither one of those, the investigator or the agent, said that it was not a prohibited weapon. They said it wasn't functional. But remember, it doesn't have to be functional at the time that law enforcement finds it. It just can't. It has to be, has the potential to be readily available, and that's what they're saying. If you remember, the ATF agent testified that these firing pins are everywhere. They're quite easy to put in. It takes no time at all. If you remember, the Van Zant investigator said, he's the one who used the term, it's quite as simply as putting a round peg in a round hole. Any idiot can do.
Right.
So neither one of them maintained that, yes, it was not functional at the time they found it. Then they didn't maintain that it was not considered by law a prohibited firearm.
Okay. Okay, because I thought the detective, the arresting officer, said that it didn't make it, that if it wasn't functional, that it didn't make it illegal.
No, that was not testimony.
Okay, then I misunderstood. That's why I'm asking. He was really hard to understand.
Yeah, he may not have been the finest witness out there. Let's go to Hawk. What do you think, Jessamy? What do you think, Hawk, on this case? What's your overall initial opinion?
I'm not sure the state proved possession because they initially were there for something else, and he was not there. His mother later testified that he did not actually live there. It was in a location outside of a living space anyone could have approached. In my mind, the state did not prove that he had care, custody, control, and management of that firearm.
So are
Okay.
you leaning towards not guilty, Hawk?
On that specific point, I'm leaning toward not guilty. On the other one, I'm having to ignore.
If it's not 2 points, then it's not guilty. Both elements have to be satisfied for a guilty.
That's where I'm leaning.
Okay, so Hawk
But
is
you have no
on
exception on the length of the fact that it is a prohibited weapon by definition. You have no issue with that element.
Not according to the jury instructions. The jury instructions, I am forced to ignore other information. So I'm not at liberty without violating our jury
No,
instructions.
I'm not asking you to do that. I'm just saying you have no issue.
Oh, I definitely have issues with that.
Okay, well, I guess we'll keep going then. Talk about it.
Okay. It was none of the people who claimed that that was a functional firearm explained how a missing firing pin would be able to be inserted, other than saying it's as simple as putting a round peg in a round hole. And I do not believe that. I have serious doubts about that. So that was not proven to me beyond a reasonable doubt. Not being a non-functional object, it would not be, from what was described, a functional firearm, because it could not fire without a firing pin. And
remember,
they did not tell me, they did not prove to me in testimony that it would be easily restored to firing condition.
so the ATF agent saying that the firing pins are readily available. You can pick them up anywhere, probably order them online, and that even different makes would it was such a common firing pin that you could take one from a different make and put it into that one. That didn't satisfy you. And the other, when asked
No.
how hard is it to put a firing pin in, the guy said it's just as simple as putting a round peg in a round hole.
No.
Okay. Let's go to Bruce Wayne. Bruce Wayne, what's your initial evaluation over this, or assessment, I should say?
I believe that they did meet the standard of proving that it was a prohibited weapon. I do have a problem with they never really explained the uh, breaking the chain of custody, which is a concern to me. And Hawk brings up a good point that they didn't like they said that they didn't prove that it was easily restored to a firing condition, so that does cast some shade on their assertions that they were not able to prove that. But was he in possession of a prohibited weapon? Yes, absolutely. So I'm still gonna have to deliberate a little more.
Okay. Vet, you come in a little bit late on this. Do you have an opinion?
Yeah, I came in a little late, just from what you explained about the case, and then listening on. Yeah, prohibited weapon, obviously by the letter of the law. Firing pins can be tricky with certain weapons, but they're pretty. I mean, for simple weapons, they're pretty easy to put in. That doesn't mean everybody knows how to, so that doesn't matter. The weapon's still against the law. As far as him having possession, if I'm not mistaken, he did move the weapon from a shotgun to the refrigerator. Am I correct?
From a vehicle to the refrigerator was his interview statement.
All right. So that shows he has knowledge of it, that he did have possession in the sense of holding it and moving it, but not in the sense of the law. The fact that he should know or not know that it's illegal by looking at it, that's, you can't really put that on him. So I'm willing to deliberate more, but right now I'm leaning towards not guilty, just in the sense of they didn't prove possession 100% for me. So
Okay.
Can I pop in
Sure.
real quick? On the intentional knowingly, he only said that he moved it after they threatened his mom. After the
That's not. He didn't say
ATF
that.
had,
No, hang on. He didn't say that at all. He said that yes, he knew it was there, but it was his mother's. The ATF agent pushed him on that, and that's when he said, "Well, I did. I moved it from a car. I don't even remember exactly what car he said, but I moved it from a car and I put it into the freezer." Is what he said. That was his statement on the recorded statement that he made.
right, wasn't that after the ATF agent said that, he didn't want to go after his mom?
Yes.
Okay. That's what I thought. So he threatens his mom with arresting his mom, or his mom getting in trouble. And then that's when the story changed, because originally I thought they had said that he didn't have any knowledge of that gun, that, he knew it was there and that was it.
knowing it's there isn't possession for sure. So just because knowing it's there.
Let me ask you guys this: in your freezer at home, do you possess everything that's in the freezer?
Absolutely
Are
not.
they your profession? Are they your possessions?
If it's in my dump trailer outside in my
But here's the thing you have to
yard,
realize.
and somebody might, I get
But
it.
here's the
It
thing
is
you have
on
to
my
realize
property.
with that. The mother said specifically that he was not living there. So you can't say, oh, just because it was in the freezer means it's his, because mother came in and said he was not living there.
I take the mother's word for about as far as I can throw her, just because the mother's going to protect its child, obviously. And if the state has proof that he's been living there, as in not just bills,
But
but
where did the state prove that, though?
no, that's the thing.
No, the state didn't prove that. Their proof was their proof was that his vehicle was parked there.
So
Also,
range.
Yeah,
Real quick.
just because his vehicle is there, that's not proof he's living there.
Real quick. Range
Right.
says constructive intent. If he was able to make it functional, he's a prohibited person. So
well, ignore range.
why did they not dig into his past on whether he had that ability?
Don't be
But
like,
also, this is the
hold
thing
on,
with the
hold on,
state.
guys.
literally telling somebody that, oh, you can find it and putting it anywhere. Any idiot can put a pin in a hole and it's done. Like, not everybody can. So, like, to me, the state didn't prove how
but
easily
the law
available,
doesn't
and
hold
that
up
doesn't
now.
mean
Hold
he
on,
intended or knew how to do it
Hang on,
either.
or just keep talking over me because everything you're saying is like really fouling the jury up. Nowhere in there does it say that you have to prove that one has the knowledge to do it. The law says that a weapon that is either functional or readily converted to a functional weapon that can shoot a projectile by use of propellant or explosion. That's the definition. There's nothing in there about how much skill level it takes to do it. Can it be readily converted? And the state's contention is that yes, you just have to drop a firing pin in it, and it's a fully functional firearm. But let me get to Just Me, our foreman. I think we've gotten everybody else's initial opinion. I want to get Just Me's initial opinion. Go ahead, Just Me, lay it on us.
All right. Well, first thing is yeah, the shotgun was shorter than what it needed to be. They proved that, but they did not prove that it was his. I have to be honest that I'm leaning towards innocent because of the simple fact that they, in my mind, didn't do a well enough job of proving that that belonged to him. Now, is it something that can easily be turned into a weapon? Sure, but that's not what we're being asked, right? What we're being asked is was the shotgun too short and was it his? And that's where I have to say he knew that the shotgun was too short, but I don't believe that they proved that it was his.
Do you have to
So
prove it's his or that he has care, custody, and control?
you're right. It was care, custody, and control. I apologize. Give me a minute on that one.
Yeah, and you know what? This case is tough, folks. I mean, you've got a guy now. Mom wasn't like mom was at work and he stopped by. Mom's been in Phoenix she lived there. She said she had this property. I think she inherited it. It had a double wide mobile home on it. Remember that? And it had a travel trailer, a fifth wheel travel trailer pulled up behind it. And folks were living in the travel trailer. They weren't living in the mobile home. If you remember her testimony, she said that the person that owned the shotgun was a handyman that she knew that she had hired to come tear down the trailer home to get it out there. Evidently, it wasn't worth living in. And that's how she became acquainted with the person with the short barrel shotgun. But subsequently, he goes to jail. I think while he was at her property, they arrest him. He asked her, and her story is he asked her to go to his house and grab a television, a few other personal items, and the shotgun was amongst that, and safekeep it for him while he was in jail. She says that she did so. But there's some months that go by between this time that this happened and the time that law enforcement shows up at the house. Now, is son there? Is he in care, custody, and control of the property? I think you could probably say that he is. Whether he lives there or he owns that, I don't think that's a question. I think, does he have care? If someone pulled up there and said, hey, can I have some of this wood that you've got piled on the side of the house? Would he have the authority to say yes? Would you think he would? I would think he would. He's there. He appears to be the owner, displays himself as the owner, and can make decisions like that. So I don't know that possession is something that we should be sticking on. I think possession is what the law is asking for us to decide. Who's a hardcore guilty? Was it you, Bruce Wayne?
No, that's not me.
What's your position?
I think if we were going off a reasonable person standard, it would be one thing. But since we're doing beyond a reasonable doubt, I don't think that the prosecution shored up an ironclad case. I still have doubts. So I'm leaning towards not guilty.
In Vet, you're still leaning towards not guilty?
Yes, just because I have the possession part, that's the one thing. I'm with Bruce on that part. It's just like, it's different if you came to my house and it's in my safe and it's just like, yeah, you have possession and it's just out back in the fridge. I don't know. And then it's for somebody else. I don't know. I'm too vague. I'm not 100%.
Now keep in mind where this fridge was at. If you were to walk into the side door of a travel trailer or a fifth wheel trailer, that freezer is sitting outside directly near that door. As you go up the steps, you could reach over and touch it. So it's not like it's sitting, in a trash pile. It's sitting, near the door.
Right, but it's also not protected either. So it's just, well, also you're in the fifth wheel in the middle of who knows what. But I don't know. I'm still leaning with Bruce. I'm not. You gotta give me 100% on that.
Well, and also something that really hangs me up is the fact that he told one story, and then once they threatened his mother, he changed his story and took the blame.
Can
That
I address that?
I don't
Well,
I
would
don't think
that,
they
would,
fully addressed it.
would
No.
that would that be true? In we used to do the interrogation show. Would that be true when the suspect sits down? Is his first story the true story, and anything else is coerced?
They
I
haven't.
believe so. Yeah.
I don't
I
think
know that
they
for me.
Go ahead.
Oh,
Go ahead,
sorry.
Moon
Go
Goddess.
ahead.
Go ahead, Moon Goddess.
I know for me that if somebody threatened to arrest my mom, that if me telling the truth, if I start out telling the truth that, hey, here's my mom's, it was in her possession. I'm just checking on the property, feeding the animals. And then if they say, well, it's a federal offense and we can go after your mom, am I going to take the blame for my mom? In a hot second. I'm not going to let my mom get charged. No way. And so, yeah, I think it's coerced. Yeah, you can't threaten somebody's mom
Okay,
and
let's go to
expect
Hawk.
them to not.
I got you. Let's go to Hawk. Hawk, you were trying to chime in there. I want to give you a chance.
Well, and it was on that specific point where he initially said something and then was told, this is a federal offense. You're throwing your mother under the bus. And then he backtracks and said, okay, yeah, I took it out of this guy's car. Okay, so now we have two different stories, but we also have two different methods by which that shotgun arrived on that property. And I don't feel like the state proved he was in care, custody, control, and management of that shotgun. For one thing, also keep in mind, as you mentioned and pointed out, that freezer was outside the fifth wheel. Anybody walking along or up to that property would have access to that fifth wheel, to that freezer rather. They did not have to go into that fifth wheel.
Right, but that fifth wheel's parked behind the really close to the double wide trailer. I don't know if you can see it from the road.
But if somebody were to walk up, that freezer would be easily accessible.
Okay, so someone else could have come and placed that sawed-off shotgun in there. What about both Mom's story and his story? That
The
this,
problem, I'm sorry,
knew,
Joe.
they knew where they got this shotgun from. They knew where the shotgun. Both of them knew where the shotgun come from. This handyman that was supposed to do work for them that went to jail.
Excuse me, Joe.
Go ahead.
I kind of feel like that's kind of more of the proof to the guilt, guys, because both the mother and the son claim to know about the gun. See, if neither one of them knew about the gun, then from the very freaking beginning, it would have been, what are you talking about? Like, we don't even go out there. That's out there. That's a freezer out there. We don't even touch that. So I'm having a little bit of problem with that because of the fact that both the mother and the son knew about the gun and they both knew about the freezer. So I'm sorry, Joe, when you wanted to look for the hard guilty, that would have been me.
Okay, it sounds like Tyler. Where are you at on this? Are you still in the middle, undecided, guilty or not guilty? Where are you at, Tyler?
So thank you very much for the opportunity, Joe. So here's where I'm at of all this. Me personally, like I feel like I'm on the fence with this one. I think I need to deliberate a little bit more. The reason I'm solely on the fence is because on one hand, you've got two versions of the stories. I mean, me personally, I would not be taking jail time for somebody else, but that's not to say somebody else wouldn't. I think the other thing is I want to know why they were there in the first place because I thought I heard somebody else say that they were there for an entirely different reason. Was I mistaken on that?
Yeah, let me give that to you. There was a high dollar value home burglary that happened in Smith County in Texas. That is an adjacent county to Van Sant County where this offense occurred. They received information that one of the suspects they believed to be involved in this burglary was located on this property. So Smith County goes out. They recognize the car that they're looking for. Their suspect is known to be driving. They see it parked at the property. They make contact. They do find the subject that they're looking for, but the defendant for this case was also there. It was his mother's property. They found items from the burglary, gold coins, and other items that reported stolen. They found in possession there. They didn't charge the subject of this trial, the defendant in this trial. They did not charge him with any aspects of the burglary. They only charged him with possession of the short-barreled shotgun that was revealed after they received a search warrant to search this property for further items used in the burglary. And that's when the shotgun was discovered.
So
Oh,
here's the
man.
other so here's the other thing. I'm not really trying to play lawyer here, but if the search warrant was only valid for the things discovered in the robbery, why was this even brought up?
Well, the way search warrants go is that when you receive a search warrant, it's going to let you look for any place where the items that you mentioned in the search warrant could be secreted. So if you had
Mhm.
gold coins or a watch, could it be secreted inside of a old freezer sitting outside?
It could.
Then that gives law enforcement the authority to look there. And if they find something that's obviously unlawful, like a short-barreled shotgun, they can't ignore that.
Mm-hmm.
So it's good. It's good under search and seizure. Fourth Amendment, there's no issue with this.
Okay, so yeah, then that's valid. But the thing is, they can't prove it's the Suns, and that's where I'm really just leaning towards a hard not guilty, is because I don't feel like the state was able to prove his, because the instructions we were given were
Hey,
specifically.
Joe.
Let him finish, Mungadas. Go ahead, Tyler.
Thank you so much.
Sorry.
So the reason I feel like the state didn't prove it was it's because the mother said that it was her property and that the son basically was not in control of it, if I heard that right. The son said it's my mother's property. Yeah, I knew it was there, but I was just here checking on the stuff. So that just to me does not prove that he was in possession of it.
Even if he was sleeping overnight there?
Even if he was sleeping overnight there, that doesn't mean he's in control of it. I mean, even if he's like, I sleep over at my friend's house all the time. Just because they have a short-barreled shotgun in their house doesn't mean I'm in possession or control of it. Just because I sleep over at a family member or a friend's house doesn't mean it's my gun.
Okay. Go ahead, Mungadas.
I'm going to change mine to a guilty
What
for
convinced you?
one reason. Well, in looking over my notes, the defendant said in his interview with the ATF officer that he had shot in the 22, and they found both the 22 and the shotgun in the freezer. So he knowingly knew it was there. He knew it was, he had possession of the 22, but not the shotgun. Well, why were they put together in the same place?
I mean, isn't it common, at least in my household, all firearms are locked up in the same cabinet regardless of who they are? So to
They
me,
weren't
that's
locked
not
up, though.
really.
Bro, they were in a freezer. I don't know if this is a standard way that a lot of people would maintain or keep their firearms.
In a freezer, no, that's quite
Right.
irregular. I would have to agree that a freezer is a little bit weird, but at the same time, like me personally, I'm just having a hard time believing that the state proved that that was his.
It
Okay.
didn't prove that it was his. It just said he had possession and care of it. And I didn't realize until I looked over my notes that both guns were in the same place. And so if he had possession of the 22, he also had possession of the shotgun, and he admitted possession of the 22, said he even shot it.
I have a
Right,
quick,
but again, that's assuming, and this you can't assume.
Not assuming, I'm going by testimony. He said that he was in possession of the 22,
Right, but just because
that it
something
was
in the
his.
but just because something in the same is put in the same spot does not mean he was necessarily in control of it, though. Like if I set my firearm next to another one, it doesn't mean I control both of them. Like that's an assumption you're making.
You're saying control, care, custody, and control or management is the way this goes. So any one of those could fit.
Yeah, so care, custody, control, and or management. Just because he places something next to it does not mean he has care, custody, control, or management of it. If I go set my 50-inch TV next to another 50-inch TV, it does not mean I have care, custody, control, or management of the other one. It doesn't. I'm sorry, but that's not
But if
proof
you're the
enough.
one on the property taking care of it, if you're the
The-
one that's taking care of the property while your mom's gone, and you put the gun that you've shot that you have control over next to your mom's gun, you're still in custody. You still have custody of it because you're in possession because you're the one in control of the property at that time.
Can I say one thing that so I do competition shooting, and there's a type of caliber, not caliber, but size pistol I do not have to shoot. My brother-in-law does. I have his pistol here at my house. It is not my pistol. It is registered to him. I have control of that. It is at my house. So I kind of agree with Moon Goddess when she was talking about the 22 was there, and then, but he doesn't have control of the shotgun. It kind of did a little bulb on top of my head. It's like, man, that's like me. I have my weapons, of course, my guns, but then also my brother-in-law's is here because I use it. I shoot it. So I do have possession and control. It's I just wanted to throw that in there just as a little add-on.
Well, you know, the prosecution used that in the closing arguments, even demonstrated by reaching over, picking up the gun and say, I'm in possession. It's in my hand. I'm in possession of it. And then he walked over and set it back on the table and walked away from it. He said, but yet, even though it's not in my hand, it's feet away from me. I'm still in possession and still in control of the weapon. So he gave a demonstration in there I thought was actually pretty decent to explain the state's theory on this.
Can I bring
Well,
up?
Yeah, I'm
Yeah,
hard guilty.
we're getting down to so we got 2 hard guilties and I think a maybe and 3 no guilties. We're getting down to the last 4 minutes, so let's run hard on this before we get a vote. Hawk, go ahead.
If you recall, during the mother's testimony, she was shown a photograph of the shotgun in question, and was asked where it was, and she said, "That's on the bench in my house." Officers found it outside. It was on a bench inside her house. She said she put it inside her house. It has been in multiple locations. Now, that I want to ask you this.
Well, I think you're wrong. She did say that's on a bench in my house, showing the picture of the shotgun. Then he showed her another picture when the shotgun was in the freezer, and he says, "Is that not the freezer?" That's when she explains where the freezer was at. So I think she was either not understanding the picture, but she reversed her testimony with the second picture that she was shown in that series, Hawk.
Okay.
So, Joe, do you
Two-
mind
two-
if we
two-
get
Okay, never mind.
Joe? Do you mind if we get a playback on that? Actually,
We're not going to have time, my friend.
Joe, I have a question. You said, but I'm still going to keep mine the same. But how did the mom even know? You said she was living in Phoenix. How does she know if her son was there? How does she
That
know
was
if he
something I was
living
not
there
aware
or
of.
not?
They talked on the phone. In fact, it was common for him to go by there and maybe stay a couple of days and just keep the place up.
Okay, I'm changing mine to guilty because I thought she was living there and he was just crashing on the couch. If she was never at that house during this whole incident, then he obviously was the one with possession of it.
She was in Phoenix with a knee surgery in quite some time. She even said on the stand, she said, "Well, I'm really just living there. I've been there a long time."
Right. And he was there taking care of the animals.
And the property, yes.
Yeah.
And you can't take care of animals and property and not be there.
You could drive in and out, but I would think when you're there, you're probably in care, custody, control. Let's go to, I think we're still teetering a little bit with Tyler and Beasley. We're close to a unanimous decision. Tyler, have we swayed you at all with any of the discussions?
I mean, so let me ask you this: how long had it exactly been, or a rough estimate, since the mother had been at the house?
Months,
Months.
if not years.
Oh, years? Yeah. Then if she hasn't been there at years, then
Her testimony was, I had knee surgery and I went to Phoenix and I was really, she said, I was just really living in Phoenix. She'd been there quite some time.
yeah, I'm gonna have to change mine at this point then to guilty, only because of the fact that, if the mother and the son were going there, then I could say, maybe the state didn't prove it was his. But the fact that he was the one solely in control of the house, he admitted to putting it in the chest. I have to switch mine to guilty at this point.
Okay. Hawk, any sway on you, or you're maintaining your position of not guilty?
Still maintaining my position because there was a point in the testimony where the rifle was found in a different location than the shotgun. And then that switched. They still have not shown that he had full care, custody, and control of a freezer that was in a publicly located position.
It's not a public location. It's on private property, dude, sitting next to a
I know it's
house
private
in
property,
the
but some
backyard.
private property that was not, I didn't hear anything that it was fenced out from keeping people from walking onto the property, like walking up my front door.
Did you hear something that indicated that it was commonly trafficked by other people?
My front door is not commonly trafficked by other
it's
people either.
well, is your back door? If you have a freezer on your
The
back
back door is not, but the front door is.
if you have a freezer,
It's accessible
never
to the
mind. Go
public.
ahead.
It's a
All right.
public location.
Yeah,
You got a
but
freezer in your
okay,
back door. Do you expect that to be public or private?
I'm not, my
Can
decision hasn't changed.
Okay. We're guys, we're
can I
at an
try?
hour.
Can I jump in here?
Real quick.
Everybody agreed that the travel trailer was towards the back of the mobile home.
It was in the
And
back of the mobile home. Yes.
Right. Yeah. It was to the back. So with it being towards the back of the motorhome and the freezer being up against the travel trailer, that doesn't make it public. That makes it private.
Okay. I'm going to go around for one more vote to see where we're at. See, we've got a unanimous vote. We're good. If not, we may have a hung jury, which is fine too. Just me. Guilty, not guilty.
Guilty.
Tyler, guilty, not guilty.
Guilty.
Vet LT3, guilty, not guilty.
Guilty.
Bruce Wayne, guilty, not guilty.
Guilty.
Kyard.
Moon Goddess, guilty, not guilty.
Guilty.
Hawk, guilty, not guilty.
Not guilty.
Folks, we have a hung jury, which, I'm not upset with that. Let's see what the verdict was.
Let the record reflect that the jury is now present and seated along with attorneys for the state, attorney for the defendant, and the defendant. It is my understanding that the jury has reached a verdict. Who is the foreperson of the jury?
Just me's the
You
foreperson.
have the notebook in which, there we go. Give that to Deputy Martinez. I'm going to inspect the verdict, and then I'm going to return it to you for reading. All right, court's returning this to the foreperson. Mr. Young, if you will please rise. Madam foreperson, if you will rise, if you will present the verdict of the jury to the defendant at this time.
We, the jury, find the defendant, Reginald Hoyt Young II, guilty of possessing a prohibited weapon as charged in the indictment.
Thank you. You may be seated. Verdict of the jury.
Okay, folks. That jury said guilty. They found him guilty on the charge of possession of a prohibited firearm, specifically a short-barreled shotgun. Not bad. What I'm going to play for you next, in the state of Texas, when a jury finds you guilty, then the next step is called the penalty phase. That's when they'll have a hearing. They'll put on, defense can put on a case. The prosecution is going to put on a case and argue for what the sentencing should be. It goes back to the jury. The jury makes a decision and actually gives you your sentence in Texas, which, by the way, every state should be like this. If your state allows a jury to convict you and a judge to sentence you, you should really make some inroads to fixing that in your state. That's called administrative justice, not real justice, in my opinion. But I'm going to let this play out. And this one's going to take a little bit of a different turn. The defendant's going to use a right that he has here to avoid the jury sentencing him. So listen up. This should be interesting.
All right. So the defendant having been found guilty, court will then proceed to the second phase of trial, the punishment phase. With the state like opening statements at this time. Court's in recess till 1:30.
Thank you, sir.
We are on record, cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury, attorneys for the state, attorney for the defendant, and the defendant are present and seated. The court previously took a recess at the request of counsel before we began the punishment phase. It's my understanding that there's a proposition from counsel. Is that correct?
Yes, Your Honor. State has agreed to resolve the case for 20 years and to 1245, the new arrest charges from a couple weekends back on manufacture, delivery of controlled substance, and evading, and a forgery.
Okay. Mr. Stevens, any response?
Yes, Your Honor, that is our agreement. And so with that being said, at this time, we would withdraw our request for the jury to do punishment and ask them to be changed to the court to do punishment.
Okay.
And Your Honor, I'm sorry, just to make sure I'm complete with the offer, that's also to waive appeal on the case.
That is correct, Your Honor.
All right. So what I want to do is take Mr. Young. I'm going to take him under oath, and then I'll.
All right, pause real quick. What happened is that this gentleman has other charges that the jury wasn't allowed to hear because you're not allowed to hear just dirty laundry on a defendant. It's got to be, has some foundation to be evidence to be brought in. So his previous criminal history and his pending charges were not brought up, but he has a pending charge for evading, manufacture, deliver in the state of Texas, which that's going to be a controlled substance charge. And then for the .22 rifle that you saw in court, he's got a felon in possession. He's a prior felon in possession of a firearm for the .22 rifle. And now you've got the guilty verdict on the shotgun. They're going to bunch the defense offered a deal. You bunch all this up for 20. We'll plead to what we're not found guilty on, and we'll get it all taken care of today. The state has agreed. Now the judge is going to make a decision as to whether he's going to do that. But what they're asking is that the judge sentence him, because he has a right to ask that. He has a right to have the jury decide, but he also can waive that right and have a judge do it. In this case, he's asking the judge to do it, and they're setting the term at 20 years.
I want you to ask those questions to make sure that he's clear on what his rights are and what he'd be waiving today. Mr. Young, if you'll raise your right hand, sir, do you swear that the testimony you give to the court today for this limited purpose will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Go ahead, Mr. Stevens.
My name is Reginald Hoyt Young II.
Yeah. We have a jury trial.
Perfect. Thank you.
All right. We just completed jury trial, correct?
Yes, sir.
You were found guilty.
Yes, sir.
Okay. You also have 3 other charges pending at this time.
I do.
One would be a first-degree felony, and the others would, I'm not sure what level they are, but first-degree felony on the first one, right?
Yes, sir.
Okay. Now, the deal that's been made today is for you to waive your appeal, accept a 20-year offer, okay, to wrap up everything.
Yes, sir.
In other words, the new cases will be what's called 1245. What that means is the state knows about it, the judge knows about it, you know about them, you're admitting that you know about them, and then they get dismissed.
Yes.
Okay. Is that your intention? Is that what you want to do?
Yes, sir. That's what I want to do.
Okay. Pass the witness, Your Honor.
And Mr. Young, has anybody threatened you, forced you, or pressured you to make that decision here
I'm
today?
sorry to have.
And you understand, Mr. Young, that the state of Texas, I'm assuming, does not have a lab report back on any of the newer charges that have been referenced to by Mr. Stevens. So the amount could come back that makes it perhaps a second degree or a third degree. You understand that?
I understand.
You understand that. And you've considered all of that, and you've had the advice of your attorney, Mr. Stevens, and you're telling me today that you understand all of those potential risks, that you're waiving your right to be indicted on those cases. You're waiving your right to have a jury, and you're asking the court to accept the 20-year recommendation of the 20-year prison recommendation of the state of Texas and waiver of your right to appeal in this case in which the jury has found you guilty for possessing a prohibited weapon, to take the other unfiled cases in consideration, meaning that you would not be prosecuted of those offenses in the future.
I do.
Do you have any questions or any concerns that we need to address before we go further?
I would just like to make sure that all of my back time that I have applied on this case, since I caught this case that I'm here for today, the prohibited weapon case on November 25th, 2020, I would like to make sure that all my back time that I have accumulated over these last 4 years is credited to my sentence. As long as that's credited to my sentence, I have no objection to anything. I'm ready to get it over with.
And the law does require the court to give you credit for any time that you've spent in jail on this charge prior to trial. Now, I know that you have been out on bond several times on this case. You understand?
So I have.
And so the only time that you're going to be credited for as back time is actual time spent in jail on this cause.
Yes, sir.
Does the state have any idea what that may be?
Not yet, Your Honor. We haven't started looking back to get the calculation started on it.
Okay. And so, Mr. Young, do you have an idea of what that might be?
I'm thinking roughly about 16 months, about 15 to 16 months over the past 4 years that I've been arrested on this prohibited weapons charge that I've spent incarcerated in jail.
And we can verify that. Let me ask you, Mr. Young, if your recollection is different than what the data shows, is that going to have a bearing on your decision today as to whether or not you accept their offer?
Well, I would like to know. I would like to know where it is, because I mean, as far as I know, every time I've been arrested and I've been on I've been arrested. Every time I've been arrested, it's been for this charge, and the bond has been, every time I've been arrested, the bond has been dropped, and I've had to make bond on it again. So I would like to know. Yes, sir. Most definitely.
Okay, prior to you entering into an agreement?
Yes, sir. If I could.
Yes.
Yes, sir.
Yeah, I think we can make that work.
All right.
And let me, hang on, I'm sorry, Mr. Hartwell, let me ask one more question before I forget. And so, Mr. Young, you understand that if we verify your credit time and it is acceptable to you based on what time you actually spent in jail, if you change your election for the court to assess punishment and to accept this recommendation, this agreement between you and the state, you understand that you can't change your mind later once I let the jury go.
Yes, sir.
You understand that there's a jury right behind that door and they're ready and willing to come out here and hear the evidence and give a verdict on that. And that range of punishment, to my understanding, potentially is from a minimum 2 years up to a maximum of 20 years based on an enhancement allegation that's been filed by the state. Understanding that if I accept your recommendation and your agreement, and I'm telling you that I would, okay, I'm not telling you that it's an if, I'm telling you that the agreement as you stated it, I would accept that. But once I inform the jury that they're free to, can't later change your mind and say, hey, I want a new jury or I want that same jury back. That would be over and done with. You do understand that?
I do understand it, Judge. Because one thing I understand is no matter what, I understand with the punishment phase, I know it can go anywhere from 2 to 20 years anyway. So for me to have new charges that I have to face anyway, it's better for me to go on and just take what I'm getting and get everything behind me to where I can get it finished and get on with my life, man, to try to do something different. You get what I'm saying?
I understand. And
Yes.
so to me, Mr. Young, it seems that you have intelligently thought through this offer and the decision you're making is based on potential risks that you could be facing in the future.
Yes.
Okay. All right. So let's do this. Were you going to say something, Mr. Hartwell?
Just a quick question, Your Honor, to make sure that Ms. Abney is looking everywhere for jail credit. Was there any incarceration time outside Van Zandt County?
There was some in Henderson County. There was some, but I was arrested on the Van Zandt. I was arrested on the charge in Henderson County, and whenever I was arrested on the charge in Henderson County, that was also a part of my. Whenever I was arrested on the charge in Henderson County, that was also a part of my. The reason I was arrested was because I had the warrant out of Van Zandt County. So I was arrested in Henderson County for something else, and I was there, locked up there the whole time, and then. It was all part of it. So after I got done with my time in Henderson County, I was brought back to Van Zandt County. This was last year. I was brought back to Van Zandt County, and my bond was reset, and I had to bond out on this prohibited weapon thing again. But as far as it goes, whenever I got stopped in Henderson County last year, and I went to jail for the time that I was there, I was stopped and I was taken in to custody for my warrant that I had active out of Van Zandt County for prohibited weapon charge.
Okay, so I'll have Ms. Abney look at Henderson County as well as Van Zandt County for that.
Any
kind of
other
time.
counties?
And I had a little bit, I had a misdemeanor charge out of Smith County that I had to go to at the same time to sit out at the same time. But I was only there like a week, maybe a week and a half, 2 weeks that I was in Smith County, but I was in, I had for all three counties. I had a prohibited weapon here. I had a misdemeanor marijuana charge out of, Smith County, and I had my, the new charge that I had in Henderson County that I had obtained whenever I had the warrant.
Do you believe when you were serving time in Smith County for that warrant or for that, you say misdemeanor marijuana?
Yes, they arraigned me whenever I was there. The day that they brought me there to Smith County, they arraigned the morning that I got there that Henderson County transported me. They arraigned me in Smith County on the prohibited weapons charge there.
So potentially you have credit time in Van Zandt, Henderson, and Smith?
Yes,
Okay. All right, then what we'll do is we'll stand in recess. I'll have Deputy Martinez let the jury know that we're dealing with some legal issues. And then if we can go ahead and try to get a back time verification for Mr. Young, then once we get that, if you'll go ahead and communicate that to Mr. Stevens. And then if that's going to be acceptable and appropriate, and we feel like that is accurate, then we'll go on to the next step.
all right.
Yes.
Thank you.
All right, court will be in recess.
Okay, when we go back, the court's going to be back in recess. The jury's going to be present, and he's going to do the official sentencing. Is anybody surprised of the criminal history of the defendant?
No,
No.
not really.
I was sentiment range minded when he was like, he's a busy boy. But he was busy, but he was very smart on bringing it all concurrent with the new charges. That was smart on his behalf, because he could have got easily more than 20 years with all
Well,
the
it's
extra stuff.
it's actually not a bad deal. Essentially, what the state's saying is that you max out on the sentence for this charge with enhancements. With his 20 years, they'll dismiss the others. So it's actually not a bad deal for the man.
And the fact that he's got already over a year in. I mean 20 is a long time, don't get me wrong, but shit, I'll take 16 months off if I could get it. So yeah.
Sure enough, sound like he'll probably get more than 16 months off. If they arraign you in jail in another county, then you're there on that charge too. It's part of the detainer. But you guys that follow me, and we will have this discussion. I hear this a lot. It's like, well, what about they should bring up his criminal history during the trial. You notice none of this was brought up during the trial, right?
Right.
And that's fair, because you're not charging him for his life. You're charging for the single offense of possession of a shotgun. So the state doesn't have the right to bring in all these other things just to soil the man's name so the jury leans their way. But that's a constitutional right, by the way, folks. That doesn't happen in any criminal trial.
Can I say something, Joe, real quick?
Go ahead.
It sounds like he's finally got his head out of his butt, that he's finally realizing that what he was doing was screwed up, that he's screwing up his life, and that he just wants to get it over with so that he can go on to do something better.
Sure. If that lets you sleep at night, that could be the case, or it could be the case that you're standing in court. You'll have that. Let's get on to the actual, because we haven't seen the sentencing yet. We're going to see the actual sentencing of Reginald Holt.
All right, we are back on record, cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of a jury. Attorneys for the state, attorney for the defendant are present and seated. All right, some understanding that the back time credit for Mr. Young has been confirmed. Is that correct, Mr. Hartwell?
Yes, Your Honor, confirmed at 329 days.
All right, Mr. Stevens, did you convey that to Mr. Young?
I have, Your Honor.
And that's not as much as what I believe Mr. Young thought at the outset.
Right.
Does that in any way affect his decision on whether or not to accept the agreement from the state?
No, sir.
All right, so Mr. Young, I've already placed you under oath earlier to tell the truth, so you're still under oath. So Mr. Young, you understand now that your back time credit is 329 days.
Yes, I do.
In understanding that, do you still wish to go forward with your plea?
Let's go.
Okay. All right, so the paperwork's being written up by the state right now, and so we'll go over all of that later. At this time, you are changing your election for punishment to be assessed to the court instead of the jury. Is that
Yes.
correct?
Yes, sir.
And you understand that I'm going to bring the jury in, I'm going to release them and let them go. And once that's done,
It's over
then
with.
it's over with. You understand that? Okay. And so you're positive that this is the decision that you want to make?
Let's get it.
Okay. All right, then let's all rise for the jury. All right, thank you. You may be seated. All right, ladies and gentlemen, at this time, I do want to inform you that your duty as jurors is going to come to an end. Mr. Young has elected to change his punishment election to have the court assess punishment instead of the jury. So this time, all of the instructions that I've given you previously about not discussing the case with anyone else, you are released from that instruction. You're free to speak to whomever you want to about the case. You're also free not to. So just on behalf of Van Zandt County, attorneys for the state, attorney for the defendant, we do appreciate you and your willingness to serve. I'm going to ask that you assemble into the jury room and give me just a few moments. I'll answer any questions you have. And I do want to give you an opportunity to give some feedback to the court on the jury process, okay? After which the attorneys for the state, attorney for the defendant may wish to speak with you about the case to get your impressions of the evidence, make sure there was no jury misconduct, and to get any kind of insight that may be helpful for them in their practice, okay? At that time, when the attorneys come in, you're welcome to stay and talk with them. You're also free to go, all right? So if you will, just give me a few minutes in the jury room. Let's all rise for the jury. All right, we are back on record in cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. The record has already been made that the jury has been discharged and released upon Mr. Young's changing his election for the court to assess punishment rather than the jury. The court finding that Mr. Young, having entered into an agreement with the state of Texas, finds that the recommendation as to sentencing from the state and the defense is for upon the court, which it has already accepted the jury's finding of guilty on the charge of third-degree possessing a prohibited weapon, finds that the range of punishment is not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court, taking judicial notice of all filings in cause number CR 2198, including the indictment, finds that an enhancement paragraph has been alleged in the indictment and alleging that Mr. Young, having been convicted of a prior felony once before, would enhance the range of punishment from that of a third-degree felony to that of a second-degree felony under the statute, oftentimes known as repeat felony offender. So, Mr. Young, I would ask you, you've reviewed the indictment with your attorney, Mr. Stevens, is that correct?
Yes.
And you've reviewed that enhancement paragraph wherein the state has alleged in the indictment that on or about June 20th, 2013, in cause number CR 09-493 in the 294th Judicial District Court of Van Zandt County, that is this court, that you were convicted of the felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. According to that accusation, is that accusation true or not true?
That's true.
That is true. And Mr. Young, has anybody threatened, forced, or pressured you to plead true to that enhancement?
No, they haven't.
All right. Court does accept the defendant's plea of true. Court finds that Mr. Young is enhanced up to a second-degree felony range of punishment, not less than 2 years or more than 20 years. Court finds that enhancement paragraph to be true. Court finds that the recommended sentence and the agreed sentence recommendation from both the state of Texas and the defendant in this case is for Mr. Young to be confined for a period of 20 years in the Texas Department of Criminal Justice Institutional Division, with court costs of $290, reimbursement fees of $255, and jail time credit of 329 days. The court hereby follows the agreement and the recommendation, and the court assesses punishment at confinement in the Texas Department of Criminal Justice for a period of 20 years, orders court cost and reimbursement fees, and awards Mr. Young his jail time credit for the time that he has spent in jail on this cause. Mr. Hartwell, I believe that you said that there was also some disposition letters that you are submitting to the court at this time to show that some other allegations in which Mr. Young has been accused but not officially charged by indictment or information. Is that correct?
Yes, Your Honor. State wanted those disposition letters to be part of this record.
All right. The court finds that 3 disposition letters from the Van Zandt County Criminal District Attorney's
Okay,
Office.
it's going to get pretty administrative here. These disposition letters, is the district attorney going to provide and involved in this case file that these other charges will be dismissed as a result of this guilty or this plea that they arranged, the sentencing plea? So, folks, that's your case. You've seen it from the indictment to the jury's verdict and to the sentencing of the defendant. Give us about 20 minutes, folks. I'm going to go around and get everybody's initial opinion from the jury. But if you'd like to join our jury, give us about 20 minutes. We'll open up a space on X for an after party where we can discuss this further without any restrictions of jury instructions. But you know what? I'm going to go to Hawk first. Hawk, what's your overall opinion of how this case was handled?
Overall, I think the defense did a disservice. They should have hammered on some of the specific technicalities of the weapon itself. They should have brought up more on, proved to me that he had possession control, management, etc., that there was intent, because they never, in my opinion, they never brought up the intent. I think that the defense really did this guy a disservice by not pursuing certain aspects of the case. I think the prosecution really didn't go, they pulled up expert witnesses who really didn't give expert testimony. They gave opinion, they gave...
and you're saying a lot of the stuff went unchallenged by the defense, and you think the defense should have challenged it?
Yes, exactly.
Fair enough. Tyler, what's your overall impression of this case?
Well, Mr. Leno, my overall impression is, again, like, I would have liked to see a little bit more proof that on the state side that that he was in control, possession, or otherwise known as, the control and possession part. I don't think the state really proved that he had possession. It was in an ice chest, but it wasn't inside of his house or anything. It was inside of a backyard. His other firearm was with it, but that to me just doesn't prove that he owned it. So I would have liked to see that. It's a very tricky, very complex case, and I'm happy I was here for it.
It's tricky, my friend. You go back to ownership. You don't have to own it. You just have to be in care, custody, control, or management. But I get you. I get your point. Just me. Your impression?
My impression is that with everything else included, okay, so the person that committed the robbery was at the house that the guy was at. This is not what the judge wanted us to do, so that's why I didn't do it. But the guy that robbed the place was at the guy's house, okay? So they were there getting the other guy for a robbery that he had caused, and the stuff was at the house. So the guy clearly knew, the defendant clearly knew that there was something awry. He had a guy in his house who had committed a robbery. He had stuff. So not only that, but I don't think there was too much to prove on the shotgun part. That was easy. A tape measure can do that. The mom being away for so long, that there's no way she could have known if what her son was doing. There's no way. So, all in all, I would definitely have to say that I do think that the defense could have done a much better job. I also believe that the prosecution did a fair enough job to prove or to get a verdict. So I think overall it was a difficult case because of the fact you're adding in so many elements. But with a guy that had committed the robbery, being at the house with the stolen items, the guy had his other firearm next to it. I'm sorry, there's just too many things that can't be answered there. So that's why I stuck with guilty.
Very well. Vet, same for you, my friend. Bruce.
Yeah, no, I thought it was a great case. I don't think that prosecution did a real good job. I think they left a lot of questions that could have given you reasonable doubt. I think where it mattered, they ultimately did prove it, but they could have shored that up a bit. But it was a very interesting case, and yeah, I enjoyed it. Thank you, Joe.
Thanks, Bruce Wayne. Moon Goddess, last but not least.
My overall opinion on the case is I think we did a good job. I mean, yeah, we were a hung jury, but had I not looked back on my notes and realized that, okay, wait a minute, he confessed to the 22's in the same spot as the shotgun. Once I made that connection and remembered that, then it was like, yeah, the defense did a lousy job of defending him. And the prosecution really didn't do a great job at proving it, but they did prove it in my eyes. But it was hard. I mean, it was a hard case, but after the fact and knowing that, this is a career criminal, then yeah, I'm pretty confident that we did the right thing.
Hey Joe, I'm back. I'm sorry about that.
No worries, friend. I just want to get you just a real quick assessment, what you thought of the case and that kind of business.
Yeah. Cool case. The defense, I thought they did a good job because, I think going into when the jury was in there, he knew that his client was getting the other charges. So I think he did a good job bringing everything together. And the prosecution probably just, they nailed it, 20-year thing. And let me just add the fact that it shouldn't even be a gun charge because, freedom and stuff, personal opinion. But no, it was a good case, man. Pretty interesting.
I want to thank each and every one of you guys for dedicating your time tonight and watching the episodes and keeping up with this over the last 4 weeks. That's why we do this, and your time and effort is not gone unnoticed. Appreciate it quite a bit. All right, folks, we're going to end this. Catch us over on X. Give us about 20 minutes. We'll kick up an after party space, and we'll cut this up even more. Thanks, folks.
Hey, Joe.
Thanks,
Go
Joe.
ahead. Go ahead.
I just wanted to say thanks, Joe, for letting me participate. This was fun. I enjoyed every minute of it. It was a blast.
Thanks, Joe.
Awesome, folks. We'll have another case, and we'll do this again. Don't forget our grand jury on Friday night. That's a staple. Every Friday night we'll have a new grand jury this week and brand new cases. Catch us on Friday, 9 p.m. Eastern, same place.